rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Ginger Box presiding, is now in session. Please be seated.
Good morning, everybody, and welcome to the First District Court of Appeals. We have two cases today that are going to be argued. The first is In Re LM. If the attorneys could please stand and state your name and your readiness to proceed.
Justin Moss, attorney for defendant Ellen LN.
Thank you.
Norbert Wessels on behalf of the state, they declare the appellee. Ready to proceed.
Okay, thank you. And then next we have Health Carousel Travel Network LLC versus Electo Healthcare Services Wheeling LLC et al.
Good morning, Your Honor. Matt Chasser on behalf of the appellant.
Thank you.
And good morning, Your Honor. Tom Glassman for the appellee. I also owe the court an apology. I had a mishap this morning with a coffee cup, which is why I'm not running it today. And I'm very sorry for that.
We'll forgive you. All right, thank you. I will be keeping your time. And, yes, got it. I'm good, thank you. I will be keeping your time. Green light means go, yellow means you have about a minute left, and red light means that your time has expired. Ms. Moss, anytime that you're ready, come on up.
Yes, I'd like to reserve 3 minutes.
Whenever you're ready.
Morning, Your Honors. Mr. Wessels, may it please the court. This case is about LM, who suffered significant injuries after a car accident. As to the first assignment of error, the juvenile court erred in not granting LM's request for competency evaluation when a reasonable basis was provided. And this is an issue of first impression across Ohio under the Juvenile Competency statutes since they've been enacted. Now, the request for competency evaluation under these statutes only requires a reasonable basis for an evaluation. And you don't even get to having an actual competency hearing unless a competency evaluation is ordered. But there's no specificity as to what constitutes a reasonable basis. But we know from the juvenile rules and the statutes that the rules and statutes have to be liberally construed to effectuate a fair hearing. And here, then that also satisfies due process and fundamental fairness for children.
So just to stop you, so there's no definition of reasonable basis, right?
Correct.
And you're saying there's no court in Ohio that has defined reasonable basis?
Not as to, correct, as to these juvenile statutes.
Okay, so this is something that we're going to have to figure out what that means?
Yes, this court would have to figure out what that means, but we can use case law such as the In Re Harris case that was from before the juvenile statutes to get to what that means and for what this court should look at. So for a reasonable basis, there has to be something more, there should be something more than just I have concerns. And here, the attorney provided much more than just I have concerns. So this goes beyond the adult case of Ely, where that was all that was indicated. Well, first of all, there was no presumption of competence because LM had a mental health diagnosis. He was diagnosed with post-traumatic stress disorder and severe depression. But even if there would have been a presumption of competence, that was rebutted by this reasonable basis of these concerns.
Do we even care?
Counsel, how do these two pieces fit together? So there is built into the statute a presumption of competence for some juveniles, and then there's the reasonable basis standard. If the presumption of competence applies, does the juvenile have to show that they've overcome that presumption in order to meet the reasonable basis standard, or do these two pieces of the statute stand alone?
They work together, but they also have to stand alone. You can't have an attorney that is making a mental health diagnosis for a client, and that's really what the juvenile court wanted the attorney to do in this case. So you have the reasonable basis for an evaluation, and then if there's then the competency hearing, then by a preponderance of the evidence that the juvenile is not competent. And it's just not reasonable to require that higher level at the point where you're just requesting a competency evaluation, because we know not all competency evaluations are going to come back as the person being competent. That's the point of the competency evaluation, to have the expert identify various different factors that goes into whether the child can assist in their defense, whether they understand the proceedings.
So the presumption piece, that's where I was getting confused. I mean, that doesn't seem to come into play until after an evaluation, and then you have a competency hearing.
Correct.
Okay, so I guess, so we're just looking at what does reasonable basis mean, and was that shown below?
Correct, for just to have the evaluation, which might have come back potentially as him being competent, but it equally might have come back as him not being competent.
Okay.
And there were concerns from the attorney who had experience working with LM that after this accident, that he had trouble processing information, he was only able to parrot back information, and she felt like he didn't understand what was going on with the proceedings, and that this was a significant change from her experience with him prior to him getting into the accident. She also indicated that his mother also had concerns about his ability to understand. She also explained about his mental health diagnosis of PTSD and severe depression, and indicated that he was also on an IEP. And while it might not have been enough potentially before he got in the accident for her to raise this issue of competency, there certainly was more information after. Additionally, she was not told that he was suffering from hallucinations, that he had been having that for the past 2 years. She wasn't told that before he got into the accident.
So, but all of that stuff existed prior to the accident. The council just didn't know about it, right?
Correct.
And so prior to the accident, council didn't have any concerns about competency.
Correct.
So what was the big change?
So the big change was not only being told this additional information, but also how he was exhibiting after the accident, and potentially that the accident contributed to this inability to then work with her as well as understand what was going on.
Was it the brain injury from the accident?
Yes.
'Cause, I mean, the fact that council didn't know about all of this other stuff doesn't seem to matter to me. I mean, if he had it, he had it, but he wasn't exhibiting any problems, right, before. So there, to me, the only thing I saw on the record that would be the big change between before and after is this brain injury that he had.
So yes, it was a big change. There doesn't have to be a big change, though. So you could raise competency at any point in time if there's a concern about the child's competence, and that's the point in time where his attorney did have a concern. And the discharge instructions from Children's Hospital, so not only did he have to go to the ER, was there for a while, then he was discharged and put in the psychiatric hospital, but they also indicated significant concerns about his inability that he would have trouble with thinking problems, poor memory.
Weren't those discharge instructions, though, more generalized? This is what happens after a concussion?
They were generalized of the possibilities that could happen, but he also endorsed having several of these issues. And the juvenile court even noted that it was aware that he had persistent symptoms, including headaches and seizures, depression, flashbacks, confusions, and was exhibiting behaviors that made the attorney question whether he understood the proceedings. So the court then put that in their entry that the court was aware of this. So the takeaway we get from Harris is that individuals who are spending more time with the child, such as a parent, guardian ad litem, attorney, may have information to inform the court of concerns about competency. And so in Harris,
Before you go on, I was a little bit confused about, did the trial court look at the correct standard?
no, they didn't look at the correct standard. They were using the standard before the juvenile competency statutes were put in place about providing, and I bling in the language, having a, it's not reasonable basis, it was a higher standard if in adult court, if a defendant's case was mid-trial. It wasn't a reasonable basis.
Okay.
Wasn't the court using the standard that you would use at a competency hearing rather than determining whether to give a competency evaluation?
Yes.
I mean, that's where it looked like they were already putting the defense to the burden in what would be more of a competency hearing situation rather than determining whether an evaluation was warranted.
Yeah, and that's exactly the case. This would be like having reasonable suspicion and probable cause and requiring a probable cause when that wasn't warranted. And so with Harris, the court then sent this back for a competency evaluation because competency evaluation wasn't ordered. And that was even though the court asked that child questions similar to what might be asked in adult court to gauge an adult's competency. And when we look at some of the other cases that come out of adult court, those are also significantly different than what we have here, because in cases such as the Hammond case, where the person had a traumatic brain injury similar to LM, had amnesia similar to LM, that individual was given a psychological evaluation by at least 2 psychologists, and then determined that that person was competent. But even though that person was competent, the person was given accommodations during trial, and the trial court then checked in on that defendant, which is not what we have in this case.
So what's the remedy here?
The remedy would be a remand back to the trial court to allow for a competency evaluation.
Does that reverse the guilt finding or the trial, or is it just to send it back just for a competency evaluation?
And that's a great question. I think it would have to vacate the adjudication, because we're now a significant time past when this accident happened, when this trial happened, and there's no way to know with those concerns that were going on that he was competent at the time of trial. And so then if he is found competent, then allowing for a new trial where we ensure that he is competent during those trial court proceedings.
Is prejudice presumed? I mean, if we determine that the trial court should have ordered a competency hearing, should we presume prejudice?
Yes. As to the second assignment of error and to receiving stolen property, there was no evidence here that the nature of the property was actually stolen. There was no questions asked to LM where he got the vehicle. There was no evidence that he stole Rass's vehicle. Otherwise, he would have been charged with grand theft.
Isn't the circumstantial evidence enough in this case, though? I mean, there was the part where you put the key was pried off, and he didn't have a license, and it was the same type of vehicle that had been reported stolen. I mean, isn't that enough evidence?
We don't believe that the circumstantial evidence here would suggest that Ellen would have known that the car was stolen. First of all, the officer only testified that there were no keys. No keys were found on LM. There was no testimony about any of the officers searching the actual vehicle for keys to determine whether the car was being driven. Additionally, it was very clear that the accident caused the significant damage to the car Ellen was driving. You have wreckage all over the road after that accident, and the airbag had deployed.
Counsel, can we focus on the key issue? And I apologize for my voice. So wasn't there testimony that the key piece of the car on the steering wheel had been stripped such that a key wouldn't even go into the steering wheel? Like a key would not have been able to be used in this car?
The officer testified to the steering column being stripped, but didn't elaborate on what that meant. And here, this wasn't just Ellen was found in the car or near the car where there wasn't an accident. Because you have such significant damage, even to the front of the car, of whether what the officer observed could have been caused by the accident. There was no pictures of what the officer observed. So that description isn't clear given the nature of the damages to the vehicle.
And what about the testimony that people in general will frequently use a screwdriver and a USB cord with this stripping mechanism to sort of hotwire the car and work around the key? Is that enough? Are you saying that this is more of a manifest weight issue as opposed to a sufficiency issue, or how should we approach that testimony?
Well, in regard to the screwdriver, so even to the assignment of error as to the screwdriver, there was a case that talked about knowing whether a car was stolen by using a screwdriver, and they could see damage to the screwdriver as if it was used to jimmy the steering column, but that's not the case here. There was no indication of how that was used or if it was used at all in this case. so that doesn't lead to circumstantial evidence of this being stolen property.
Your time has expired.
Just briefly, Your Honor, as to the third assignment of error, because the court specifically did not make a finding about what LM's actions were, there was no way for the trial court to determine that LM's actions directly and proximately caused the loss to Ms. Rass. And I'll reserve whatever is remaining of my time.
Thank you.
Good morning, Your Honors. Opposing counsel. Judge, can you hear me okay? Judge Kinsley? I wanted to start off by addressing a question that you had, Judge Krause, about the whether or not the court had applied the right standard. I think that the entry that the court entered does indicate that the court followed the right standard. Specifically, they did find that there was no reasonable basis to conclude that a competency evaluation was warranted. It's RC 2152.52, which is the code section that talks about that initial step of determining whether or not a competency evaluation is warranted. And so
Okay, so you would agree, though, that or you can tell me what you think as far as where this presumption comes in. Does it matter at this stage?
So as I read I think it's 2152.51, it talks about the child competency evaluation. It's not that, it specifically reads that a child is incompetent if they're incapable of understanding the nature and objective, and it says they're incompetent. It says they could be incompetent, and then it lists different things that could cause that incompetency: mental illness, developmental disability, or a lack of mental capacity. The language regarding a presumption deals with that third element, that lack of mental capacity. And it says specifically that if the child is 14 years of older, and presuming they don't have a mental illness, they're presumed to lack that mental capacity. So I think the presumption doesn't go necessarily to competence as much as it does specifically to that specific thing that could cause incompetence of mental incapacity.
So it's something to be evaluated in determining whether there's a reasonable basis for an evaluation?
Right. I think that the requirement of the court when they're determining that reasonable basis has to look not just at the mental capacity, but as to the existence of either a mental illness or another developmental disability in order to determine that ultimately the question of whether or not they're capable of understanding the nature and the objectives of the proceedings against the child. I think it's the state's position that there was no reasonable basis found. I don't know whether or not it's up to this court to determine what the exact definition of a reasonable basis is. As I read the case law, I think, and as I hear opposing counsel argue, I think we're somewhat in agreement that the mere suggestion of incompetency is not enough. It's not enough in adult court. It's not enough in juvenile court. This is a fairly particular circumstance that this court was faced with, in that at the time that these charges arose, there was already an in-progress trial. And so this request for competency came not only in this sense, where it was a pretrial determination, but the court had to determine whether it would put that other trial on hold in order to make a determination of whether or not this child was competent for the purposes of continuing that other in-progress trial. And so to the extent that there's reference to the adult statute for the standards to examine when examining an in-progress trial competency request, I think that's why I think we both agree that there's no guidance in the revised code as to that situation in a juvenile circumstance. So when we're looking at the standards that the court was reviewing, I think they were trying to take guidance from the adult court in that sense. When we look at whether or not there was a reasonable basis shown, as the court has already pointed out, the issues regarding the juvenile's mental illness or proposed mental illness were things that happened years prior to this incident, and I think concededly by counsel below was not an issue, did not raise any suggestion of incompetency up until she learned about it.
But it was, the intervening thing here is that he suffered a brain injury in this car accident. So wouldn't that be enough, along with what counsel says to the court, that he's just not registering when we're talking? Wouldn't that be a reasonable basis?
I think if the only thing that could be suggested is that there was some sort of brain injury, I don't think that's enough on its own. I think there has to be some sort of indicia. I think that's what's talked about in both of our brief, that there is something that would cause the court reasonably to believe that they're incapable of understanding the charges against them, or incapable of following along.
But at that point, like before, when the defense is asking for a competency hearing, the trial court is not looking about whether the juvenile is incompetent. The trial court at that point is only looking at whether there is a reasonable basis simply to order this evaluation. So I think that the two things are being conflated a bit.
I think so. In terms of when you talk about specifically at that point, in terms of the point that the court is looking at it, in order to determine whether is that reasonable basis, the court in this case took a step back and set the case out multiple times in order to get as much information as it could in order to determine whether it should hold, whether it should continue on that case or order a competency evaluation, specifically due to the nature of the injury that was alleged and the things that were alleged by the counsel in this case. And I think, as I read the facts, as I examine the evidence, the only thing that was shown up until I think it was in just around June when the court made a determination not to order a competency evaluation was that the juvenile had suffered a mild concussion. That's what the medical documents refer to it as. He was in a car accident. There's no question that he suffered physical injuries. But based on the court's own observations of the juvenile, which this court is supposed to give deference to, and of the information that was provided to it, the only thing was shown is that he suffered a concussion, a mild concussion, the remedy for which was a few days rest. And I do not believe that that provides the sufficient indicia of incompetency for the court to get to that reasonable basis. In other words,
But that's not by itself. I mean,
Right.
doesn't a defense lawyer's discussion about their interaction with their client carry great weight? If a defense attorney is saying, look, when we're alone together, I don't think he's fully registering what I'm saying. Doesn't that carry great weight, though?
I think it definitely carries weight. I think the case law supports that the court is supposed to provide weight to that, and I think that's what the court did in this case. In addition to that, as both this court and opposing counsel has said, a defense attorney is not a medical professional.
Well, right.
that's
That's
why
why they
you need
wanted
to-
to evaluate.
Right. Well. In determining whether or not it's reasonable, the court in this case specifically asked to look at the medical documents and to get an update on what the juvenile was experiencing at the time. And I think that in consideration of those things, viewing what the defense attorney said in the lens of the medical documents, the court's own observations, what was actually alleged to be causing this, I don't think that the court found that it had not gotten to that reasonable standard. In other words, there was none of that indicia that was required in order to order a competency.
So are you saying, so defense counsel has private conversations with their client and says, this is the way he interacts with me. And then the court talks to the client in court and says, oh, he seems fine to me. I mean, isn't that basically what happened here?
I don't think so.
Okay.
I think my analysis of the case is that the court set out this case multiple times. I think there were 2 continuances in order for the defense counsel to provide some sort of indicia that would require a competency evaluation. The reason I think that is because this juvenile was involved in this car accident. I think they were in the hospital for 2 weeks. They suffered this concussion. By the time that they had gotten out, they had a hearing with the judge. The judge was able to observe the juvenile and indicated on the record that it didn't notice that anything was actually wrong. And so the court said to the defense counsel, if this is what you're saying, I need to have some more indicia that would require competency.
Give me an example of what else defense counsel could have set forth.
I think had there been a indication that, for example, the concussion had been more severe, had anything in the medical documents indicated that the juvenile's ability to understand, it's not, I think that there is some amount of burden when you're requesting a competency hearing to show these things. And
How high of a bar does the defense have to jump to get a competency evaluation? I mean, a reasonable basis seems like a pretty low bar.
I would agree with the court. I think that in this case, upon viewing everything, the court made a determination that there wasn't this sufficient indicia.
Where does the sufficient indicia come from?
I think it comes from, it's my reliance on case law that's relative from the adult court that are examining the same standard. So I'm not referring specifically to anything from the revised code. I believe it's the state's position that in this case, there was although it was a brain injury, it was not sufficient to cause the court concern, even with what the defense counsel was saying in order to get to that reasonableness standard. I do think that the court properly examined, didn't make a knee-jerk decision based on it took the time to look at least what was provided to it in terms of this request, and I do believe it came to the correct decision. If I could address briefly some of the other assignments of error. With regards to the second assignment of error, I do believe there was, especially considering the weight to which the juvenile court reviewed the evidence, there was sufficient evidence in order to grant an adjudication of both of these charges. Specifically, when it comes to the evidence that the court reviewed, this was the case where the juvenile was found in the driver's seat of the vehicle. The steering column was stripped. They had a USB and a screwdriver on them. I think there is sufficient circumstantial evidence for the court to find that the car was stolen in this case.
And there is testimony, I think the officer testified that the screwdriver and the USB is a method of being able to start the car without keys.
Correct. The officer testified to that as well. It's my understanding, at least what the officer testified to, that there are a certain number of cars, specifically I believe it was a Kia in this case, that can be accessed, whereby either a delinquent or a criminal would go somehow gain access to the vehicle, pry open the steering column with a screwdriver. There's a little USB port that's in there. You can insert a USB and attach your phone to a USB cord, and that starts the vehicle. There was a lack of keys found in this case. Obviously, the officer was indicating that was the method of access to this vehicle for the juvenile who didn't otherwise have access to this car.
It seems it would have been much more simple just for the prosecutor to have matched the VIN numbers or license plate numbers in this case.
I would agree.
Seems like a major oversight there.
That's with respect to matching specifically the alleged victims.
Or to make sure, or just to prove it was a stolen vehicle.
Right. But either way, both the magistrate below and the juvenile court both found that there was sufficient evidence to show that the vehicle was stolen and that the juvenile was in possession of that stolen vehicle, which I think is the standard that's required.
Well, what about restitution, though?
Do you have a more specific question?
Yeah, so what Judge Krause just said about wouldn't it have been a lot more compelling had the state matched the VIN numbers instead of, it seems like the restitution order is resting on the one statement on the video where the officer said this was stolen from, I can't remember what neighborhood.
It's difficult for me to say exactly what the restitution order is resting on because it wasn't contested below. In order for the court to get to the standard that opposing counsel referenced of determining direct and proximate harm, the court would only have to make that determination if the amount or the restitution order was contested. In other words, because juvenile didn't contest that below, the court never had to make a determination. They, in effect, accepted the state's proposition that Ross was the appropriate victim on this case, and so they have never had to make that determination. Had they had to make that determination, I do believe that there was sufficient evidence in order to determine that. Ultimately, had there been a restitution hearing, it's the state's proposition that and this court has ruled this way in the past, that the state would not have been bound to the testimony at trial in order to determine. If we're talking about direct and proximate cause to the vehicle and whether or not Ross is an actual victim, I think it was assuming that is her vehicle, it was uncontroverted that his use of the vehicle, his being in receipt of the stolen property and causing the crash was a direct result that caused harm to the vehicle. So I do believe she's a victim in that sense. But again, we didn't have a restitution hearing below, And so there was nothing on the record in order to get to those types of questions because it wasn't contested.
And just real quick on the first assignment of error on the competency, if we were to agree that there should have been a hearing, what is the remedy? I mean, do we reverse the adjudication, or does it just go back for a hearing?
As I stand here today, I'm not exactly sure. I would think that, as I read the case law, it would probably require the court to reverse the. It's a difficult setting because we have at one point we have an in-progress trial that was going on. This case, as it relates to the competency evaluation, it was before the ultimate. It was, I think, when the court reached its decision as to competency, it was 2 months before this case went to trial.
Right.
So I don't necessarily believe that a reversal is warranted, specifically because of some of the facts that was reviewed. The trial court also said, when making its decision, both in relation to this case and the in-progress trial, that opposing counsel has the opportunity to raise competency if it believes, in regards to this case, that competency is still an issue, and that was never raised. And so I don't know necessarily that a reversal would be warranted. But obviously, if a competency evaluation should have been done and the defendant was deemed incompetent to stand trial with relation to this, it would have to be reversed.
Okay, all right. So if we were to determine that the judge should have sent him for a competency eval in this case, what do we do?
I don't know the answer as I stand here today. I would think that it would have to be set back for a competency evaluation, but whether or not that would have any bearing on it would have to depend on his state of mind when the actual trial took place, which was, again, months after.
Okay.
Your time has expired. Are there any more questions from the panel? Okay, thank you. You have about 2 minutes.
In this case, only the screwdriver was actually listed in the complaint for possession of criminal tools. So although there's been reference to the USB cord, that was not part of that charge.
But that was part of the testimony, correct?
It was part of the
So
testimony,
we can
but
consider
not.
that when we look at whether the vehicle was stolen, whether he had knowledge. I mean, we can still consider that for, maybe not for the, that specific piece of equipment for receiving stolen property. I mean, we can't look at that as far as criminal tools, but we can consider that in other contexts as far as why he had that.
And I think a USB cord is going to be found in every single car across America. I can't imagine one right now that doesn't have a USB cord to charge a phone, to use it to access parts of the vehicle. As to the restitution piece, it was at a minimum plain error for the court to make this restitution order. And the officer, part of the video that the state had relied on about an officer saying a car was stolen, that was not presented during trial, was not subject to rules of evidence. The magistrate did not review it. There's no evidence that the judge reviewed it at any point. So as this court decided in Olan, that is not subject to this court's review on appeal. And just because a car is stolen in Cincinnati doesn't make it one specific person's car if there was nothing to tie a VIN number, a license plate, personal property in the car, evidence of it being stolen directly to where the defendant committed that act. You can't have restitution in that type of case. For those reasons, we ask that this court reverse and vacate LM's adjudication, or reverse and remand for further court proceedings in juvenile court. Thank you.
Okay, thank you. This case has now been submitted, and we will issue a timely decision.
Thank you.
If the next two attorneys can come up, please. Whenever you are ready, you can get started, and I'll start your time. Would you like to reserve?
Yes, Your Honor, 3 minutes, please. Good morning, Your Honors. May it please the court. Matt Chasser on behalf of the plaintiff and appellant Health Carousel Travel Network, LLC. We are asking that the court today reverse the trial court's decision granting defendant and appellee East Ohio Hospital, LLC's motion for summary judgment for the following reasons. The trial court weighed evidence which is contrary to the summary judgment standard, and the trial court also construed evidence contrary to Health Carousel, which is again contrary to the summary judgment standard. Evidence was presented that appellee's purchase and use of the assets from defendant Electo Martins Ferry constituted a de facto consolidation or merger, or was a mere continuation, so that accordingly we're respectfully requesting that the court reverse the trial court's decision. I'd like to provide a quick background factually about why we're here today, and then go into the two legal issues I think are before the court, which are de facto consolidation or merger as a theory of liability, as well as mere continuation as a theory of liability. Health Carousel is a staffing company. It provides healthcare professionals to healthcare facilities. Defendant Martins Ferry was one of those facilities, and it provided healthcare staffing services and incurred debts as a result, and was owed money as a result. There's no issue that has ever been raised with Health Carousel services, none. But they were never paid for. And the reason that they were not paid for is because defendant Martins Ferry and appellee East Ohio Hospital entered into a transaction that left defendant Martins Ferry insolvent and allowed appellee to obtain the assets and certain liabilities it needed to continue operating the hospital free and clear.
Counsel, it seems to me that one of the more difficult facts in this case is the 2-year period of closure of the hospital before it resumed operations. Can you address how that 2-year period of closure plays into the successor liability hallmarks for both de facto merger and business continuation?
I'm aware of the trial court's determination that, Your Honor. I think the period is a little long. I think the invoices for Health Carousel concluded in February of 2019, and the supposed asset purchase agreement was closed in May of 2020. So that's really just about a year before those invoices became due between that time period and the time period in which the asset purchase agreement occurred. I do believe there was some ramping up after the asset purchase agreement occurred, primarily with respect to these medical records, which are one of the liabilities that appellee picked and chose through to determine to proceed. But the fact that there isn't, it isn't instantaneous, I don't think changes the conclusion of whether or not a mere continuation or a de facto consolidation and merger occurred. I hope that answered your question.
Just to be clear though, so the hospital shut down in February of 2019?
Well, I know, Your Honor, that our invoices were dated through February of 2019, which would make them due earliest the end of March 2019, but in all intents and purposes, probably after that. And the asset purchase agreement was entered into in March of 2020.
In May of 2020?
May of 2020.
So I'm just trying to understand, because we have this person, Albertini, and I'm trying to understand like who he is and his relationship to both of these, and the fact that he left and went and worked out of state and came. I mean, I'm just trying to figure this timeline out.
I think it's an important point, Your Honor, because that is the point that I think is one of the instances where the trial court went and construed reasonable inferences against us. So Albertini was an officer of the seller, Electo Martins Ferry. He left Electo Martins Ferry and went to work in Arizona. And then miraculously, he came back.
But what was his role when he came back? Was
He
it,
is chief operating officer, I believe, or chief administrative officer. But importantly, in Appalachia, there are only 2 officers. So he's 50% of the new entity as far as the
So
officer.
he has ownership interest.
He does not have ownership interest.
Okay.
He is an officer, but not an owner. We do not have a continuity of shareholders here.
Okay.
We're readily able to admit that. But the trial court said, well, this 2-year, it focused, in my opinion, on the wrong part of it. This 2-year separation of Albertini shows there was nothing wrong. Now, mind you, the trial court also said this whole transaction, quote, was suspect, and it was, quote, an end run around our system of honoring contractual obligations. And the trial court said it was, quote, trying to repossess a car which has already been stripped of parts. Now, this was after it ruled on summary judgment, but for whatever reason, in the instance with Albertini, the fact of import, the one that would go to the trier of fact, is that he returned. Not that he was gone. Why did he miraculously come from Arizona to Martins Ferry?
Well, that's what I was trying to understand, because apparently the hospital was shut down for a period of time.
Yes, I believe.
So the way I was looking at this, and correct me if I'm wrong, is that he left to go work somewhere else while the hospital was shut down, and then when it reopened, he came back.
I believe that's all accurate.
Okay.
And I believe a reasonable inference from that could go into these elements that we have to show, which is a continuation of the previous business activity and corporate personnel, the immediate or rapid dissolution of the predecessor corporation, or the assumption by the purchasing corporation of all the liabilities ordinarily necessary to continue in the predecessor's business. And those are what have been referred to as the hallmarks of the de facto merger or consolidation, and that is the place where the trial court weighed the evidence.
So, counsel, are there any facts in the record as to, or to support the inference that you're making that this, I'm reading into the subtext of your comment about this being a miraculous return to the hospital. And I hear in that subtext that you do not believe this was a coincidence. Are there any facts in the record to support that inference that Albertini had perhaps planned all along to come back to the hospital? Or is this just something that we're to read into what happened?
That's a great question, Your Honor. I think that there is evidence that we would present at trial by virtue of newspaper articles that we have discussing Albertini's role in trying to entice a buyer. This was a very important issue in the town of Martins Ferry in the Portsmouth area. Is that in the record today for the deposition of Mr. Albertini? I cannot cite you to that point of the record in the deposition of Mr. Albertini. I think it is a reasonable inference nonetheless that he didn't come 3,000 miles across the country solely by virtue of the fact that a new job opened up. I think the new job opened up, but what is in the record is that the seller was able to remove $5 million of liabilities by selling the assets and transferring certain liabilities for $250,000 that it never received. And I think that is the evidence upon which is in the record that you can use to establish it isn't a coincidence that Mr. Albertini came back.
But then isn't that a fraud claim? I mean, what you're suggesting there is some kind of intentional divestment for the purpose of shedding liability. And to me, that sounds like fraud, but fraud is not what was pled or argued. So can you square that up for me?
Sure. I think that the fraud is an intentional misrepresentation, and we never established any evidence of intentional misrepresentation. What we established was a debt was owed, there was no dispute about the debt, and then a very creative set of transactions guised as an asset purchase, which was really releasing the seller of all of its liabilities and taking on the assets and operating the very same business without those liabilities present. So Health Carousel's ability to get paid was based on potentially leaning those assets or marshaling those assets, and that was removed from them by virtue of some very creative lawyering to omit the assets or transfer them to the new entity and free and clear of those liabilities.
Can you talk a little bit more about the $250,000? And is this relevant to the de facto merger analysis or the continuation analysis, or both?
That's a good question. I think that the overarching principle here that the trial court missed was this is not so rigidly analyzed, and some of it is somewhat circular. I would tell you that lack of consideration, or inadequate consideration, lack of arm's length transaction, those are factors that are inherently looked at in the mere continuation analysis.
Did you all show that this $250,000 was inadequate consideration?
I think you can infer it based upon the evidence that we did show. You have a 130-bed facility, you have $5 million or more in liabilities, and you have money that doesn't even come into the receipt of the seller. And the trial court's already ruled that the seller is insolvent as a result of it.
Where did the money go?
It was unclear, but it went to a secured lender as a reduction in payment, and this had to do with some amount of confusion related to how the lease was assumed to operate the hospital in the same facility, or if there was a new lease provided. But there was an entity called MPT, and that was the entity that was controlling that. But so on the mere continuation theory, the appellee is correct to cite the case of Counsel Services, Inc. versus Zofco. We think that case is distinguishable. First of all, it did not involve any exchange of assets in that case. And when I talk to you about that circular issue, what they're saying in Counsel Services is that the real inquiry is whether the new business was a reorganization of the old one executed to escape the old one's liabilities. That's exactly what we have here.
But there was a change in ownership.
Correct.
Okay, so if it were the same owner, I would be able to follow your argument a lot more clearly, but since there was a change in ownership, how does that work?
Well, again, I think that the idea is that you do not apply these factors rigidly, and it's a fluid test, because candidly, once you set up, 4 factors and they have to all be shown, any good lawyer is going to figure out a way to play with the factors so that we won't be able to show them. So in that instance, there is not the same ownership. I agree with you. But why was the transaction done? The transaction was done so that the seller could get rid of its liabilities, including $5 million of them, and including the $100,000 or so owed to Health Carousel, and they could reopen the business with the same beds, the same furniture, the same medical records, the same equipment, the same licenses, the same Medicare and Medicaid, and other similar assets. And they also took on certain liabilities. And I think in an asset sale, we're buying assets. I'm buying the bricks, I'm buying the cups, I'm buying everything. But here, they were buying liabilities as well. And I think when you start picking and choosing which liabilities you want to purchase, you run the risk of getting into a de facto consolidation or merger, or you run the risk of mere continuation.
The liabilities that they purchased were, software contracts and things like that to keep the hospital running?
Related to the medical record. So
that would make sense, right?
Sure.
Otherwise, you can't run a hospital.
Sure, and I think the factor you're talking about, Your Honor, is did the purchasing company assume all the liabilities and obligations ordinarily necessary to continue the predecessor's business? Absolutely.
That's the de facto merger.
That's the 4th element of de facto merger. Now, appellee says we've presented no evidence on this. The trial court says you haven't presented enough evidence of de facto merger. Respectfully, I don't think either's correct. What is correct is we presented sufficient evidence of 3 of the 4 elements of de facto merger so that we can go to trial. We can have our day to cross-examine witnesses and get to the bottom of why Mr. Albertini came 2 years later or across the country from Arizona, or why the $250,000 was the right number. So I think in that instance, I think I'm out of time.
Yes.
All right. Thank you so much.
Thank you.
Good morning. And again, I apologize for my wardrobe malfunction. After 31 years, that has not happened to me before. One of the key distinctions here coming out of the gate is that we're dealing with an asset sale and not a stock sale. And that's a profound difference, because what we frequently encounter is when a distressed business is looking to sell itself, it doesn't necessarily have the same leverage that the buyer has. And the distressed company has to make the best deal they can for themselves under the circumstances. I think that's what most likely happened here.
So I think everybody agrees, including appellant, that prong of de facto merger is not there. Does that mean that there's no de facto merger if we're missing a prong?
Well, I think the fact that we're dealing with an asset sale, not a stock sale, that is relevant when you look at the mere continuation argument.
Okay.
That we have a completely different entity with completely different ownership, only one carryover
Right.
of staff. And I think the talk about Mr. Albertini, at the risk of being impolite, is nothing more than a conspiracy theory. And there's nothing in the record to support the conspiracy theory. And conspiracy theories make for interesting reading for a board late at night, but as far as looking at the record, there's nothing in there just to support that conspiracy theory. So the distinction.
What happened with
I'm sorry.
him, is what happened with Albertini, though, just so I understand, is that he just left and worked elsewhere while the hospital was shut down?
That is my understanding. And, my understanding is that he was based in Southeast Ohio, and I think it wouldn't be a conspiracy theory to say somebody wants to come home. I mean, we all do that all the time.
And Counsel Albertini was deposed by Healthcare Cell, correct?
Correct.
And no facts were revealed in that deposition to suggest support for what you're calling the conspiracy theory.
That is correct. So when we're looking at the four different exceptions under welcome for successor liability, it's already been established that the first exception and the fourth exception aren't applying here as far as any express agreement to assume the liability or fraud. So we're really focusing on de facto merger and mere continuation. And looking at de facto merger, first of all, we know, for example, it's a different entity. We know it's different ownership. It's still in the healthcare field, but at the same time, a different set of services is being provided. The fact that it's being provided at the same physical location is really immaterial, because when you have a building that's a hospital, when you have somebody who buys it, there's really only a finite number of uses you can use for a facility like that. You can't overnight turn a hospital into an auto plant or a shopping center. I mean, if it's been designed by an architect as a hospital space, that's the most logical use for it.
What do you mean by different set of services, though? I thought it was a hospital that was a hospital.
The types of healthcare services being provided under the new ownership is different than what was provided by the prior ownership. There is some overlap, but as far as if you walked in the doors today versus, say, 2018, 2019, there's not a complete overlap between the suite of services being offered to patients.
But it's functioning as a hospital.
Correct.
With the same phone number, location, and some of the same employees, right?
Yes, as far as, there's been a lot of talk about Mr. Albertini. As far as people who are higher up in the food chain and in a management capacity, he's the only one I'm aware of. As far as the people who are more boots on the ground, providing day-to-day patient care, I can't tell you how much or how little overlap there is for the people who are in the trenches actually providing the care to the patients. But you're correct. I mean, it's always been used as a hospital, but just as far as the types of patient services being provided, there are some differences in patient services now compared to, say, 2018, 2019.
So really, I mean, what you're saying is it's still functioning as a healthcare facility, as a hospital, but like maybe they don't do a particular type of knee surgery that the predecessor did, correct? I mean, when you say the same services, it's all, they continue to, see patients and do surgeries and.
The focus is narrower now than it was under the prior ownership. So right now, the primary services are acute care and long-term care. Under the prior ownership, you had doctors who were on staff. You had actual doctor's offices, on site or adjacent to the hospital, and you don't have that anymore.
Okay.
So, I'm not saying as far as the services provided that it's apples and oranges today. I'm just saying that if we're doing a Venn diagram, there's not a complete overlap.
Okay. And I want to focus in on the de facto merger, the second prong, second hallmark, the continuity of shareholders resulting from a sale of assets in exchange for stock. Have you seen any case law anywhere where a court has found a de facto merger when that hallmark is not present?
No.
And has there been any case law that you've seen saying that that has to be there?
No, and if it was, I would have, certainly
Sure.
made sure it was in the brief. But again, just, going back to the owner, and I'm sorry, did you finish your question?
Yes.
Yeah, but again, going back to the ownership question, the LLC that exists now simply has one member and who had no involvement with the prior ownership. What's also important is, one of the other factors we discuss is whether or not there was a rapid dissolution, and that also is not present here because we know, and the trial court references in their decision that at least as recently as the deposition phase of the case, the prior entity still existed and had not been dissolved with the Ohio Secretary of State.
But it's insolvent, right?
Correct.
So it's basically defunct.
Correct. They did, but again, the question is, when you look at the Welco case, they talk about dissolution versus being insolvent or being defunct, and then during the relevant portions of this case, there had been no dissolution.
So dissolution is required. It just, not the fact that it's just sitting there insolvent.
Correct.
Okay.
Yes, because dissolution was actually one of the terms expressly used by the court in Welco when they set forth the factors that we need to follow in making this analysis. And as was discussed a little bit earlier, as far as what was and wasn't assumed, it was really the bare minimum in order to maintain the operation of a hospital, because just the tangled web of regulations that hospitals have to go through, whether to be compliant with Medicare, Medicaid, state and federal regulations. It was unavoidable that certain things had to be assumed, in particular software, because a hospital cannot operate without that, either as far as accessing medical records, complying with Medicare requirements, or providing patient billing. So it was really just the bare minimum.
But would you agree that that's enough to overcome, for them to have shown that prong, there's evidence on that prong?
No, because under Welco and Flower and the related cases, the mere fact that some of the liabilities may have been assumed, that's not enough to allow a plaintiff to survive summary judgment. So I think you have to really look at the big picture, and when we look at the big picture here, the assumption of just a few liabilities, that's not enough evidence to get plaintiff to where they need to be. Because if you look at the bigger picture, in order to reopen the hospital and resume operations after almost a 2-year hiatus, there were a number of steps that the new entity had to do. They had to get new licenses, they had to get new certificates, they had to get new permits, they had to recertify different operations of the hospital. So there were a lot of things they had to do that, almost essentially starting from scratch.
Is there anything in the record to explain why it took 2 years to reopen?
I'm not entirely sure about that. I know that during the time the hospital was shuttered, there was physical work done to overhaul part of it. How long that work took, though, I can't tell you. Whether we're talking about 2 months or 2 years, that I can't answer for you. Pivoting then to the mere continuation argument, the Flower case makes it clear that simply operating out of the same physical location isn't sufficient to allow this argument to fly. It's undisputed. We have two completely different entities organized and incorporated with the Ohio Secretary of State. And again, not to beat a dead horse, but what we're dealing with here is an asset sale and not a stock sale, and that's of tremendous significance here. That's everything I have this morning. If there are any other questions, I'm happy to answer those. Otherwise, I'll sit down.
Okay, thank you.
Thank you.
You have about 2 minutes.
Thank you so much, Your Honor. Picking up on a couple of the questions of the panel here this morning. First is it required to have continuity of shareholders in order to find a de facto merger or consolidation? I would direct the court, and the answer is no, it is not. And I would direct the court to the case of Bondex International, Inc. versus Hartford Accident and Indemnity Co. And I'm going to read directly from that case because I just had the ability to read it while opposing counsel was arguing. And it says that Reardon and Republic shareholders exhibited no continuity, however, is not fatal to defeat a de facto merger. So the answer to that question is yes. Picking up then on the other question that the panel asked regarding dissolution, is there a requirement that there be dissolution? Again, the answer is no, there is no such requirement. And I can direct you to the case of Delphi Auto Systems versus Universal Pallets. And I have a quote from that case as well, and that is, continued, albeit anemic, existence of the predecessor corporation was sufficient to demonstrate this factor. So the idea here, which the trial court didn't follow, was that these factors are fluid and they are each judged at their own time. And in this instance, the trial court was very rote and formulaic and rigid in requiring each of those factors to be established, and that's not what's required. And then it weighed the evidence contrary to us, and it did not give us the benefit of the inferences to which we were entitled. And for those reasons, I think the trial court's decision should be reversed.
Thank you. Your case has now been submitted. We will issue a timely decision. And those are all the cases to be argued today. Thank you very much.